maybe not in the ways that you think. Because today's show is a little bit different in the sense that obviously a lot of
And good day, good afternoon. I said good day and good afternoon all in once. That's really a good way to put the English language together. Way to go, Steve. Hey everyone, I'm Steve Ferreira, CEO of Ocean Audit and host here at Ocean Freight TV. Welcome to today's edition of Ocean Freight TV. And I almost titled today's show The Curious Case or Strange Case of Benjamin Button, but we're going to go with a little different BB combination, and we're going to talk about the very, very interesting and curious case of Bed Bath & Beyond. You see what I did there? So, hey, that was pretty good. That was actually ad-libbed in the last 10 seconds. Benjamin Button, Bed Bath & Beyond. I guess today's show is meant to be. So I really want to give a shout out to a good friend or follower and comrade in arms on LinkedIn, Stephanie Loomis. Stephanie, thanks. You're part of the inspiration for today's show. I was thinking of a way to, convey a case, right, that many folks on LinkedIn and in the industry is view significant. And I want to give my kind of contrary perspective on why I don't think it's so significant, but why I also think that carriers end up shooting themselves in the foot for a lot of different reasons. And I think there's a lot to be learned from the so-called docket filing process at the Federal Maritime Commission. So if anyone is, just to recap, kind of where I'm coming from, Bed Bath & Beyond filed a $32 million formal, what we call a formal docket at the Federal Maritime Commission against OOCL US and OOCL Europe as the holding company in terms of violations of the Shipping Act, in terms of service contract compliance, performance, enforcement, allocations, detention, demurrage, and really everything they could think about in order to look at a possible repatriation of some $32 million. The case is very curious, very interesting. In some ways, it's very strange. In some ways, it's very dark in the sense that the retailer has declared a chapter filing. And so now this is kind of all being put in after the fact, or post-filing, in a post-filing status. So we'll see how this plays out. But today's show is really meant and built around dissecting some of the tenets of the case and giving you my expert commentary on my outtakes on the case itself and where the case might be going. And before I do that, I think about my tenure of being expert witness at the FMC. I believe I've been on 4 cases. It might be 5, but for sure, 4 cases, where the case necessitated a formal docket. And for everyone that needs to understand kind of the filing or claims process at the once you get to the FMC level, obviously there are commercial ways to file claims and refunds, and that's what Ocean Audit does. That's my core business. My core business is getting refunds that are amenable to both parties, right? So in other words, it's not a conflict like, hey, you didn't refund me, so now Steve's going to come in and file a suit against the carrier. That's not how my business works at all. My business is very, black and white. You focus on rates that should have been paid, were billed, contract rates that were offered, detention to merge terms that were offered or not honored. And when I say not honored, meaning that the detention rate was billed at $100, it should have been billed at $65. So at Ocean Audit, we don't get into law. We don't get into every jot and tittle, right, of what happened in the nomenclature, unless it's relevant to the case. So the FMC has various levels of escalating a case that a client might say, you know what, damned if we do, we're going to go full bore out legal, and we're going to take this case to the mat, right? And so in that case, you have a couple options at the FMC where you can have the Office of Dispute Resolution that the FMC set up, where it's not really a formal or an informal setting, but it's more like both parties can hear the case out. And the whole idea is, can they get it resolved without going into a informal docket or a formal docket? And so an informal docket is a claim process where the amount in question is under $25,000, and an informal formal docket is when the matter involves a case in excess of $25,000. Now, that's kind of old school, right? That's kind of the way the lay of the land was before OSRA, and it still is the law of the land. There are those three avenues. OSRA has introduced a new way of disputing, and I call it the kind of the nickel and dime way by the FMC introducing the so-called charge complaint process. And we all know that's been an abject failure. And again, I'm a big cheerleader of the FMC. I think they've got some great talented people. They've been a service to me over the years, and they're well-intended government employees. But they don't have the commercial chops really to understand all the nuances. A few of the ALJs, administrative law judges, obviously get into the weeds on case law and going back into the 1920 case or 1940 case. But some of these can be interpreted so many different ways. The commercial application of how ocean freight is done today in 2023 is very different than the way that some of these public servants were trained to do their roles. And so they're very well intentioned folks. It's just that there's a little bit of disconnect in terms of what their take is on a market versus reality. So if you look at it from the perspective of what the Federal Maritime Commission has done, before we get into the strange case of Bed Bath & Beyond, is the FMC has introduced the so-called charge complaint, which really has, in some ways, because of public perception, superseded both the informal dispute resolution, the small claims resolution, and then the large claims resolution. Everything seems to be moving now to the charge complaint process. Now, it's interesting, rightly or wrongly, this may be a great diversionary tactic on the part of the FMC to introduce the charge complaint, because in 2022, I believe the FMC's Federal Maritime Commission's budget was about $30 million, and in 2023 it's $40 million. So they don't really have the staffing or the horsepower to get too deep into the weeds. I tell you what, this Jamaican blue coffee is just too good, so appreciate it. And when you're a talker like I am, you need to keep, you'd say hydrated, but you need to keep those beans coming in. So you see, that's just an important thing here at Ocean Freight TV. So getting back to the case at hand, I think that the merits on looking at recoveries, this Bed Bath & Beyond case is just, for so many reasons, it's fascinating. And I'm going to get into a little bit on why that is. And I think that when I look at, recoveries, I start to think, okay, we play as we go, we pay as we go. And, we look at the whole dynamic of ocean freight, right, as the sum of the parts, right? We don't look at, on some, when you're achieving a budget or a contract, you're looking at, okay, what's on both sides of the ledger. You don't just say, okay, I'm going to ship, and then afterwards I'll worry about what was on the equal sign and how do I rationalize it because I didn't do a good job, managing it as the flow went on, right? And so, in fairness to BCOs all over the world, I get this. One of the studies I did is, I call it 2 men or 2 women and a couch, right? It just seemed that every Teams or Zoom meeting that I did, and I've done thousands, right, in 2020, 2021, 2022, and especially in 2021, it's 2 men or a man and a woman or a team on a couch, right? It's a couch in one guy's garage and a couch in the other lady's house, or and everyone's working from home, and there's a disconnect between the sum of the parts, right? So, the account payable person is in Paramus, New Jersey, the logistics person's in Austin, Texas, the operations person's in Sunnyvale, California. And so I get that there's a lot of disconnects that caused what we call Containergeddon, the term I dubbed, and then obviously, post Containergeddon fallout in terms of, okay, kind of clawing back, right? It's a cat claw, right? That's why I look at this case that we're going to discuss today as kind of a clawback. Now, clawbacks can be a good thing. And usually, what I do in Ocean Audit is I remedy a quick clawback by, having a prescribed way to go in and look at, data a certain way on day 1. And by day 10, coming back with a, validated or verifiable recovery that both parties agree on. Now, again, recoveries and refunds in ocean freight are different than litigated refunds, right? So you have to think that anything that goes to the FMC is really a body of quasi-law, right? They have judges, they have process and procedures, but they're not, a de facto commercial auditing company, right? They don't say, yep, OCL, you overcharged, you pay this. They don't. They go through something called discovery and elongated discovery. And when we get into today's show, we're going to see a little bit about what that means and what the pros and cons of that are in terms of how a curious case of Bed Bath & Beyond potentially will go forward. And it's just really interesting, when you look at this case, I dived into it every jot and tittle. I've got a really great comprehension of, why I think they did what they did, what the outcomes are, what type of operating system they may be attempting to work under, and especially some of the actions of a competing ocean vendor and how that the actions of that vendor play or predominantly factor into the first couple of pages of this case. So with that said, why don't we get into it? And, this case is pretty messy. And this is messy, and it's like, my first thing is, I'm a big pasta fan. Everyone knows that. Even with my 70-pound weight loss, I still love the stuff. And growing up as a kid in Massachusetts, shout out to Lorenzo's in Middleborough, Massachusetts, best pasta in the world. And maybe back then, but now it's changed, of course, with my taste being upgraded to having lived in Europe, so I can maybe accentuate the European side of food as well. But food is important, and when you talk about food, you throw something against the wall here. My kids are getting older, but they're not going to ruin the walls in our new house for sure, like this. But this is a mess. And with good pasta, sometimes you need cheese with it. And so Swiss cheese, not so much. But how does a carrier like MSC get involved in this OOCL case? So now we're kind of delving into the case of Bed Bath & Beyond, and we're talking about some of the interesting commentary in the FMC docket. And by the way, if anyone wants to follow along, it's really easy to follow the FMC cases. You can just Google in FMC, Frank, Mary, Charles, space, reading room, READING, space, room. And it will bring you to all the dockets for the last 5 or 10 years that the FMC has. One of the things that will impress upon you in looking at the dockets is just really how few of them are existing, given the turbulence of Containergeddon. Now, yeah, I mean, in the last year or two, there's been an increase, but relatively speaking, these cases stink to high heaven in a lot of ways because they just take so long to litigate. And, at the end of the day, it's feasible. Like one case I was on where the recovery awarded by the FMC was about $200,000. Now, if the client had just gone the traditional auditing route, where, we look back on the last 3 years of shipments, we probably could have recovered $300,000 or $400,000. But the big thing here, right, guys and gals, with FMC cases is the legal fees. The legal fees, right? So anything that goes to the FMC, trust me, I look at every case there is because I always take away tidbits to help improve my own business at Ocean Audit. Out of, say, I don't know, the 400 or 500 cases in the last, say, 10 years. I'm just making that number up. It's a relatively small amount of cases. I can think of perhaps 3 or 4 cases where somebody attempted to do the case on their own without an attorney. Right? Remember, the people looking at these cases at the FMCs are judges. They're attorneys. They have a strong legal foundation. So you just can't say, refund you $100. Okay, they got to pull the invoice. They got to pull the tariff. It's going to be really interesting when we get more into today's presentation about what that entails. But I look at this case as a little bit of a Las Vegas buffet aftermath. And by that I mean, think about, one of my favorite actors is Chevy Chase, and we have the Vegas Vacation movie. Probably have seen it 100 times. Just hilarious. And, I can relate to that movie just because of the comedic genius, right, of Chevy Chase. And I think that you look at this one scene in the buffet where it's like, okay, something blue and it's chicken, right? It's blue and it's chicken. That doesn't really compute. And this case is a little bit like that. It's like, the other analogy I could have said, it's like, throwing everything in the kitchen sink and seeing what sticks. But if a singer were ocean freight, it would be Taylor Swift. And, I am a Swiftie. Yes, at 62, I am a Swiftie. And, the thing about Tay-Tay is, we have to pay big bucks, right? We don't pay, the rack rate. We don't pay the tariff rate of, what's on the ticket. It's just like that big game in February. I can't say the name because it's trademarked, but, it says on the ticket, $500, but nobody pays $500 for that ticket. And it's the same with Taylor's concerts, right? Listen to me. Holy cow, I cannot believe I'm going there. I'll tell you what. Shout out to Sarah Barnes Humphrey and our love for Adele. I looked at Adele tickets the other day. It's $30,000, right, for row 1. It's like in my wildest dreams, I could afford to pay that for Adele. But the thing about it is that singer fees, concert fees, are a lot like ocean freight, right? There's a certain amount of pay to play. And ocean contracts, hey guys, for what it's worth, right? I'll have all the lawyers after me on this one, but ocean contracts have never really been the most enforceable documents, over the last 10, 15 years. So that in itself is one of the challenges that comes into play when you start talking about, well, we want to get our $31 million clawback because you didn't honor our commitment. You wanted us to pay, a double blue, gold. I'm making these crazy things up. On Monday, it's Monday. It must be Monday, so it's a $4,000 supplement. It must be Friday, so it's a $2,000 supplement, but only for the first 20 containers. So, I mean, hey, listen, I get it, right? The ocean carriers were their own worst enemies, trying to create these crazy rules, almost like airline pricing. But it's not something that was done collusionary, right? And the FMC, this is something that doesn't get anywhere near close to being publicized, which it should. The FMC came out and said, hey, it's not collusion, it's the market. It was the pandemic, right, that caused the iterations that are really named in this complaint. So, if I'm a OCL, I'm going to pull that quote out, and I'm going to use that in my defense. And I don't have it ready for our show today. But I remember the commissioner saying this, and that they weren't pinning the blame on the ocean carrier, and that's until kind of Biden got to them and said, we will go after the ocean carriers. So and that's a little bit of the reason why I'm maybe challenging the overall dominionhood, right, of the FMC to resolve and settle complaints. Now they'll come out on this one, and we'll talk a little bit about when they'll do it and how they'll do it. But I think the issue is that it's almost like my dad was in building maintenance for many years in the school system in Massachusetts, and I remember a couple of summers back in the let's see, I was born in 60, so maybe like in 68, 69. 70, it was right around the time of, I think, Apollo 11 in 69. And so I would, as a 9-year-old, I would come in, help my dad. He'd be working in the school system, getting the buildings ready for the school year. And he was a great painter, right? And so the next slide I have is, kind of a play on words here, lead paint or primer, or you could say leader or primer, right? So it has a lot of kind of double entendres there. But my dad was a great painter, and he painted a single school, a pretty good sized school, single-handedly. And I remember it was an old lead paint thing, and he had to, even back in the 69, he had to take precautions to work with the lead, and I don't even remember the whole 9 yards of it, but God knows, probably so much of that's in my bloodstream still. But obviously, lead paint is outlawed. And when you look at this case, is the case that Bed Bath & Beyond doing, are they a leader or a primer? You know what? You'll have to forgive me. There's one point I wanted to make. If I can go back to the previous slide, I didn't answer the one question specifically, and I know guys and gals will have a question for me about. I was talking about spaghetti so much, I forgot about the first bullet. How does MSC Mediterranean Shipping get involved in an OCL case? It's an important point. So there was a case back in 2021. It's a strange juxtaposition, but there was a company called MCS Industries. So very close to Mediterranean Shipping, but a totally different company, obviously. MCS Industries is an importer, or BCO, and MSC was one of the vendors. And so the Bed Bath & Beyond case is making the same kind of de facto arguments that MCS Industries had made against MSC, right? And what's interesting about this, without kind of going into why they did it, the lead attorney on the Bed Bath & Beyond case said, well, our case is very similar to the MCS Industries case that Mediterranean Shipping defaulted on, right? And ended up with a $1 million judgment against MSC that I don't believe it's paid yet. It may have been paid. I know MSC, I think, was appealing it. But the bottom line is that the Federal Maritime Commission said to Mediterranean Shipping, you're in default because you didn't produce the discovery and all the evidence, to get the case rolling along. And it was interesting, right? So Mediterranean Shipping's defense was, well, we're governed by Swiss secrecy and privacy laws, and then there were sworn statements in the complaint from the Swiss police on the practice of disclosing, in corporate intel. And so it was interesting because it's the first time ever in my lifetime in following these cases where I noticed that a entity like Mediterranean Shipping defaulted. So normally, right, that would be cause for, the Me Too connection, right? And so it's like I do in my audits, for example. If I find a $10,000 refund on a sample of 3 invoices, I can pretty much be sure that if I do juxtapose the full extent of the invoicing, that there'll be more than the 3, right? Especially if the 3 were in a specific time frame or origin destination zone. So you kind of focus on, okay, here's some small facts and let's expand it to the full case. But this was one of those cases where MSC almost walked away in some ways that they would be in default. Now, they claim they're not because of the Swiss laws. However, the FMC says, okay, well, you owe $1 million to MCS Industries. So my argument on this is that MSC, Mediterranean Shipping, is very smart, very intelligent corporation, and they're not just going to give away $1 million like that because they don't want the Me Too add-on effect to say, okay, well, anyone can do this, and MSC is just not going to respond. So MSC, Mediterranean Shipping, was trying to do the right thing, but the argument is that because Mediterranean Shipping did not comply, that this is the same reason that Bed Bath & Beyond is using to say, hey, they must be guilty, right? And so it's a completely, counterintuitive argument that is kind of the lead argument of the case. And so anyway, back to the lead paint, primer paint, I just think that, this is one of those things where enemy spelled wrong here, but carriers are their own worst enemy, because in the Bed Bath & Beyond case, you have a lot of correspondence from salespeople, sales reps back to the client. We're going to extend the peak season, or we advocate that you should extend the peak season. So it's, carriers can be, commit some pretty good sins, with the correspondence. So this is I might start a company on teaching ocean vendors how to communicate, properly. Of course, my work is with BCO, so I'm half kidding. But the fact is that, it's great to be able to use carrier correspondence against them in whatever way suits you. And so, there are some real gem and some truth bombs in there that, carriers do end up being their own worst enemy. And they don't necessarily make it any easier for their own well-being, to have a case be successful. So, but I think that we talked about service contracts being enforceable. And, maybe on a Monday, if it rains cats or diamonds. But in the past, ocean contracts have been very challengeable in terms of whether there's enforcement or penalties or any kind of clawbacks or shortfalls in the contract itself. It's almost like a wink and a smile. We'll move on. So I think again the industry has a lot to learn from the enforcement issues. Now I think it's getting better. The pandemic helped us to see and clarify how we want to contract and work together. So, again, a lot of the issues in the MSC, in the OCL Bed Bath & Beyond case were old templates that hadn't been adjusted to account for the pandemic. And remember, the FMC said, hey, the pandemic was, the cost overruns were not collusion. They were really a situation having to do with the time and the event itself. So I think that if you look at this case, Bed Bath & Beyond, my major problem with it that I talk about on LinkedIn is that, they waited until the very end, right, to throw everything against the wall, to have that spaghetti sticking. Whereas if they mitigated the clawbacks over time, it could be very easy. Hey, let's look at the 2020. Let's close that out. Let's look at 2021. Let's close that out. My advocation on post-auditing or pre-auditing is, if you do it, it's like prevention. It's like the apple a day type thing. You got to understand the idiosyncrasies of what you're being billed, rightly or wrongly, and you're going to learn about the malpractices. Now, again, is it going to stop the so-called alleged collusionary aspects of a carrier, predatory pricing against a client? No, it's not going to stop that. Remember what I said in my earlier arguments is that recovery auditing is not meant to be a legal process, right? It's a legitimate legal process to follow in the steps. And I'm saying that out of the $32 million that Bed Bath & Beyond is looking for, it's entirely feasible that 4, 5, or 6, or 7 million of that could have been clawed back in real time and may not even be a factor. I mean, just the fact that they got to a number, the $32 million recovery that they're looking for might really be $4 million, right, in terms of real dollars. So I'm suggesting that that could have all been offset through a functional or an audit process that would have served them in the way that would have allowed them to do the recovery and retention of their working capital. And so it really does come down to the last kind of thought process on today's show, and thanks for watching today. It's kind of feast or famine, and I wanted to find a slide that showed, the devastation of a field and the green shoots of a field. I think that the cons in a case like this is that, I had a 4-year case where it was just the $200,000, and I could have got the $200,000 in about 15 days on my own. The client got the $200,000, but they also paid a $200,000 legal fee. So I think it's feast or famine in some ways when it comes to the FMC case docket. I think that the pro here is that, this is one of those cases probably, and again, I'm not party to this case at all, but this could be a case where legally, right, the attorneys could be operating on a contingency basis as opposed to, say, an hourly fee. All the cases I've been engaged with, at least to my knowledge, the client pays a legal fee of, $300, $400, $500 an hour. And so, chasing ambulance analogy is almost like the old personal injury attorney, right? And, we were in Vegas recently, not for a Dell concert, I wish we were, but I saw all these billboards. You don't pay until we win. You don't pay a fee, And I thought to myself, they must be doing my business, right? So am I chasing ambulances? But then I thought, well, it's personal injury. So, I kind of get like it's sharks around blood. If you get into a fall off a ladder, was the ladder defective? And then, they go through all these studies. But the bottom line is that recovery auditing and cost containment is a legitimate, obviously functional area that you could look at any enterprise or BCO that has an internal audit department, accounts payable, recovery. It's a classical, traditional way, and it's been that way for 100 years in terms of the corporate recovery process. But this process is a bit like, okay, and here's my thinking, and here's what got me thinking about this. There's probably about 15,000. Maybe more. 15,000 is probably conservative. It's probably in this Bed Bath & Beyond case, 15,000 invoices in play. And so, it's like you got milk, or you got 60 minutes. So the way I look at it is you probably need 60 minutes, right, at least, to investigate each invoice. And it's 900,000 minutes, 338,000 hours. And at $500 an hour, right, that's about 19 million. That's not even going to trial or arguing through the docket process. So it's clear to me, and this was like my aha moment. And the reason why this is being thrown against the wall is it really doesn't matter at the end of the day what Bed Bath & Beyond gets, because it looks clear to me that, with a $20, $25 million, $30 million legal fee, and a $30 million, give or hope for in terms of a settlement, it's clear that this looks more and more to me like it's contingency. Now, I may be dead wrong, but I'm just telling you, how I see things from my lens here, my red and black lenses. And just in closing on the show, I think when you look at the output here, right, it's just one of those designated things where, it's just so many legal hours and so much to look at that it really, it can be cut in so many different ways. Now, this case is made up of ocean freight, detention, demurrage. And so what I would have done, and what I advocate everyone out there listening to my voice is that this is a good example of what not to do, right? You've seen those kind of things on the internet, do this, don't do that. Matter of fact, I think there's a book, a video series about this. So if I was to close the show and I would say, do this, I would say audit, pre-audit, post-audit, use me, use someone else, but make sure you keep up and keep current. Don't do this, and don't throw everything against the kitchen sink just because you think that there are righteous circumstances that's going to gain you a settlement. If my case for $200,000 dragged out for 4 years, a case like this, we'll all be talking about autonomous cars being the norm before a case like this would ever be potentially ruled on. Or, probably more likely, you'd see one of these things, confidential settlement, right? Where, and I'm just making this up, where the vendor pays, a small fee to kind of, make amends or cover the legal costs. And I'm not suggesting that's the case at all. So I think it's a fascinating topic. I'd be glad to, you've gone a little bit over here, but I'm glad to answer any questions that you folks have on this mysterious Bed Bath & Beyond case. I think certainly there's recovery opportunities for every single beneficial cargo owner. I have never met a BCO that I haven't been able to generate, at least a mid-5, low six-figure refund for. And that is your true way to understand the lay of the land in terms of what issues and problems you have. The problem at Bed Bath & Beyond is a legal problem. The problem that BCOs can prosper from and experience from day to day is an operational issue that is good for all parties, and it's win-win because not only do you win recoveries and protection of working capital, your ocean vendor partners learn their pitfalls and downfalls and make a more harmonious partnership with you as they improve their invoicing quality and control. So do this, but don't do this. Thank you for listening to today's show, and I'm Steve Ferreira, your host at Ocean Audit and Ocean Freight TV. Connect with me on LinkedIn, YouTube, follow me at stevef@oceanaudit.com. Follow me on LinkedIn, communicate with me. Let me know how I can help or be of service. Until we meet next time, have a great weekend, and thanks for watching this edition of Ocean Freight TV. Good day.